We've worked together on a few arbitrations and commercial disputes, and Lawrence is a specialist in our disputes and investigations group and works regularly on life sciences disputes. I come more from an IP and patent background, and a lot of that diet has been in the life sciences. If we can go to the next slide. Why is arbitration particularly well suited to life sciences? I've jotted down a few points to start with there about specifics of the industry. Clearly, there's the science, whether we're talking about biotechnology or chemistry or aspects of formulation, manufacturing, distribution, cold chain, etc. And during some of the presentations earlier, we've heard various comments about the regulatory regimes in different aspects. And commercial practice, of course. The life sciences is an area where there is a lot of collaboration and partnering, and that's all governed by contractual relations. So there are many occasions where there will be parties, counterparties, and there'll be some contractual relationships, and matters may not work out as planned, and there may be a dispute. Now, just to mention that in the absence of any, in an ordinary contract, you could specify that disputes are resolved by arbitration, and that's quite often the most common way that you would end in arbitration proceedings. But the alternative is that the agreement may be silent, and the parties may actually elect to do something in an arbitration context rather than going through the publicity of the courts. And we can talk about that as well a little bit later. So I've just listed there a few example disputes and corporate transactions, a breach of warranty. For those who've had the pleasure of corporate M&A work, you'll know that a purchaser is, basically it's buyer beware under English law. But to shift or manage the risk, a buyer may seek assurances from the seller. It may seek warranties as to certain aspects of the business. And, the seller, if they agree to that, they'll warrant certain facts, and they may, for instance, be warranting about status of any disputes, and they can disclose against that. But you could have a situation, and in fact, this is a sort of a common example, where what was represented to the purchaser, it turns out later that there is actually some gap between what was disclosed and the reality when the company has been purchased, and there may be a warranty claim. And this can happen in life science transactions. I've listed there partnering as another area where you may see disputes. So it's quite common in life sciences to have partnering, and I think I said before, in the life sciences sector, there's plenty of partnering going on, and when one thinks about partnering, you have a licensor maybe licensing some IP to a licensee, and that licensee may be endeavouring to manufacture, commercialize, get regulatory approval. And there may be an issue there about what level of effort that counterparty uses. There may be clauses in there that require endeavours to reach certain milestones. And we see in those agreements things like reasonable endeavours or best endeavours. And, there is a difference between the two, clearly. We can talk about maybe reasonable and best endeavours in a whole sort of session at some other time, but one can see that a reasonable endeavour at a lower threshold may involve some element of subjectivity, and it may not require that person who's acting to sacrifice their own commercial interests in order to fulfil their contractual terms. So there would be some interesting legal but also industry-specific issues if one has that kind of a dispute. IP licenses, quite often you see products and a debate about whether something falls within the license and whether it's royalty bearing. You may have supply agreements, and actually the AstraZeneca supply agreement has been particularly in the publicity recently. It's somewhere between a supply agreement and a partnering agreement in the sense that it was forward-looking, and I'll comment on that a little bit later. But ordinarily, one might see with a supply agreement money claims, and there may also be termination if one party just isn't holding up their end of the bargain. So we see these kind of disputes in the commercial disputes context, and in arbitration they are particularly apposite, because I think the main thing that we're going to just touch on now is why arbitration is a useful forum. So Bex, if you could just move us on a slide.
Great, lovely. Hope you can all hear. Thanks very much, Chris. So Chris has talked about the types of disputes that we handle and that we come across. But we wanted to just give a quick reminder of why arbitration is particularly suitable for life sciences commercial disputes. So the first point on the slide is confidentiality. So there's no public hearings or publicly available documents in an arbitration, and there's also obviously no media coverage. And that can be important because the issues that arise in life sciences commercial disputes tend to involve considering highly sensitive commercial information, including market penetration, market carve-up, pricing of medicines, royalty rates, licensing terms, revenue and profit projections, costs of sales, sometimes regulatory approvals and rejections, and potentially even consideration of formulations and proprietary processes. And so there's a strong incentive we find amongst our life sciences client base for that debate and the determination of those matters to remain behind closed doors, which you get in arbitration. I mean, that's not to say that at the end of the case, the parties are not free to release some sort of joint statement or press release, and we do see that happening quite frequently. And there may be many reasons for that, including, for example, if one of the parties to the arbitration is a listed company, and so material payments or commercial outcomes following the conclusion of a dispute might require some form of public disclosure. And in a settlement, of course, the typical provisions around confidentiality in any event are going to be incorporated in a settlement agreement with the usual carve out for disclosure to regulators and advisors and HMRC and so on. So the whole arbitration process is very much cloaked in confidentiality and privacy, and that's a real attraction. The next point is the procedural flexibility, and that is a perennial attraction of arbitration. So the parties are free to decide how many arbitrators they want to determine the dispute, what their specialist skill set is, what their background or expertise may be, their nationalities, and often arbitration in the life sciences is very international. So, having a mix of nationalities can be important. The parties can choose the seat of their arbitration. They can choose the venue for their arbitration. They can choose the language for their arbitration, and they can choose whether or not an appeal might be allowed against an arbitral award. And so all of this is obviously by stark contrast to court litigation, where the parties are confined much more so by the local procedural rules and the way that the case is managed by the court system. I'm going to touch upon this a little bit later, as it is a bit more nuanced as a subject. But in commercial life sciences disputes, being able to choose a subject matter expert as an arbitrator is often seen by our clients as being a major benefit when compared to court proceedings, where your relevant commercial judge, over whom, of course, the parties will have no choice as to which judge they get, either at the interim stage or at the final hearing. That judge may not have heard many life sciences cases, and so may not be as familiar with the issues. Something that Chris has touched upon as well, but just worth reiterating, is that in life sciences commercial disputes, there is often an IP or a scientific element, and then a commercial and contractual element. And that may be in relation to a patent, for example, that's applicable, and the geographic and temporal restrictions in relation to that, and the scope of licensing issues. There may be issues concerning the API and its manufacturing process and its composition, whether it meets contractual specification. And there will be lots of contractual and commercial issues, including the interpretation of the contractual rights and obligations, disputes of fact on issues such as termination. Was the termination lawful? Was there a breach of contract, and what are the consequences? In commercial life sciences disputes, one often looks at defences such as waiver or estoppel, and we consider complex damages calculations, and those can require expert evidence. So taking all of that into account, and particularly given obviously the industry focus, in let's say a 3-member arbitration tribunal, if that's composed of, say, a patent licensing expert, perhaps a formal commercial director in a pharmaceutical company, and maybe a sort of senior barrister, the party's ability to select that mix of decision makers with that blend of skills and experience is a really valuable benefit of arbitration that's not available in the court context. The other point is there's a lot of flexibility around case management in arbitration. So, as I said before, the procedural rules govern the way that cases run through to their hearing. But in arbitration, there's a high degree of autonomy on the parties agreeing their procedure, perhaps subject to if an arbitral institution has been chosen as being the governing body of the arbitration. But generally, parties draft their own orders, try and resolve things as best they can between themselves, and only go to the arbitrator for final blessing. It works both ways, of course. If you have one party, perhaps your opponent, who is delaying or being obstructive, then my experience is that arbitrators are a bit softer on case management than the judges would be in the court, and have less case management powers than are available in the court, such as unless orders and other types of sanctions and so on. But generally, procedural flexibility is a big benefit. And then just touching quickly on enforcement and Brexit. So, as I said, many life sciences disputes are cross-border, and parties are in 2 or more jurisdictions, and arbitration lends itself very well to that, because arbitral awards are capable of enforcement across borders much easier, generally speaking, than national court judgments, as they are enforced under the New York Convention, to which currently there's 164 states are parties, and the national courts where enforcement happens are only able to set aside an arbitral award in very limited circumstances. An arbitral award under the New York Convention is binding on the persons between who it's made, and the local court where enforcement happens will give it recognition on the production of the award and the original arbitration agreement. So it's a lot simpler process. And as for Brexit, we've certainly seen a rise in choice of arbitration in life sciences contracts, and life sciences companies coming to us and asking for advice on this, because obviously pre-Brexit, there was a lot of very helpful EU law around contractual governing law, tort governing law, jurisdiction, recognition and enforcement, and service of court proceedings. And that is phased out, or is being in the process of being phased out. So the post-Brexit world and that uncertainty for litigants is avoided by choosing arbitration in contracts, which is a bespoke contractual dispute resolution mechanism, bypasses the court system. Chris.
Thank you very much, Lawrence. And just a couple of points there at the bottom. Because arbitration is confidential, it isn't going to be creating a precedent there that will bind you in the future. So if you have particular forms of agreement and terms, and you arbitrate, then you'll learn perhaps the outcome of those clauses in the context of your dispute, but that won't necessarily bind you for all those other agreements that you've executed over the years. So that's highly relevant. And the point about informality and preservation of relationships, I think, isn't to be underestimated. We operate in a world where in the life sciences, what comes around goes around, and containing a dispute within an arbitration process rather than through the courts can avoid, I think, some of the worst breakdowns in relationships, and can often help preserve them. Certainly, Lawrence and I have had experience of that, where the resolution of an arbitration didn't mean that relations between the two parties were severed forever. They still had an ongoing relationship. So well worth bearing in mind. Bex, could you give us the next slide?
Great, thank you. I'm very conscious that we started a bit late, but I'm conscious that it's now 1:03 and you all must be very hungry. So I will try and get through the next couple of slides in about 5 minutes. So do bear with me. I'll be rattling through, but hopefully touching on all of the key points. So I think this is obviously an important consideration. It's important in litigation as well, but I think the reasons I'll explain it's particularly important in relation to arbitration. So the first point to note is pre-dispute discussions between the parties. So in most of the life sciences contracts that I've resolved disputes on, there's often a long gestation period where the parties have disagreed on something, fallen out a little bit on something, and they're trying to figure out a settlement, a negotiation, perhaps a variation to the contract. And the key commercial issues always come out of those discussions. And perhaps I would say this, if you work with your disputes lawyers during that stage, rather than just bringing them in when it's, fists slammed on the table time, you actually can work out the key concerns and the key drivers of your opponents and position yourselves better in pre-action correspondence, and even start to do some evidence gathering to see how well supported your case might be if it goes to arbitration. So all of that correspondence in the run-up to the actual letter of termination is really important to position that and to carefully draft that. And so I'd recommend involving your disputes lawyers in that stage. As for the point about how much you reveal of your case, so notices of arbitration are actually very flexible documents, and they're different from particulars of claims that one would submit in the court situation, which require quite a lot of detail, a listing of pretty much all of the facts in some detail, and you're supposed to put your case in full so it's understood by the other side in full. Notices of arbitrations, there isn't a prescriptive way of doing that, and so I've had situations where we've chosen to leave out certain details, maybe the details which are a bit tricky for us, and see what the response is to the notice of arbitration before deciding whether those are then deployed either in a reply or in a full statement of case. So just important to bear that in mind. Also, front load evidence if you can, and fact finding. Identify your key documents as early on as you can, and ideally do some witness proofing, because we often find that when you do that exercise and you really get into the detail with your witnesses of what happened and why, important issues can come out which then can dictate how you decide to express your case in a formal pleading. The other reason for front loading of evidence and documents is in arbitration there is the risk of memorials. So I'll give you an example of that. I acted in a case where a manufacturer of a novel type of inhaler in respect of respiratory medicine to treat certain asthmatic conditions entered into a collaboration with a pharmaceutical company in the target market. And the agreement provided for the manufacturer to obtain local marketing approval by a certain date. It didn't meet that. And then there were arguments on both sides as to whether this was a contractual breach. And go back to Chris's point, one of the clauses was commercially reasonable endeavours. So the local partner commenced an arbitration seeking damages for loss of profits that it would have earned in the target market, plus its investment costs. And the tribunal ordered the parties to put their cases by way of memorials. And if you haven't come across this, it's quite intensive. So your entire case, including all of your supporting evidence, fact evidence, expert evidence is necessary, has to be filed in one submission, along with all of your factual and legal case. And in the case I'm talking about, we had 6 months to do that, which was not a lot of time to do all of that. Now that's less common than the sort of consecutive staged approach, but it does happen in arbitration in a way that it doesn't in court litigation. And so it's just another reason to front load your fact finding and evidence gathering. And then next slide. Thank you. So just touching on this issue of selecting the right arbitrators, obviously I talked about that before, and that, you know, this is a real benefit for arbitration, but just remember it can be double-edged. And the reason I say that is that, you know, I've had cases where it partly depends on the merits of your case and the particular points that you're trying to run, and whether those are purely contractual or come down to market practice, or it's a mix of both. Sometimes having a member of the tribunal who is not a pharmaceutical expert, if you think that in terms of market practice, you're on the weaker side of things, it might be beneficial to actually just choose a sort of commercial lawyer. So just to bear that in mind. As for the number of arbitrators, obviously one arbitrator is cheaper, but it just means that the selection of that person is even more critical, because you obviously just have to try and agree with the other side who that might be, or otherwise it would, you know, it would go to a third party to decide. 3 arbitrators is more expensive, but in my experience, it generally results in a better outcome for clients, because you just have more influence over the outcome. You can choose the person that you want, and then also you can work with the other side in most situations to appoint the chairperson of the arbitration of the arbitral tribunal, and you will think about the identity and the skills of the person that you chose as your arbitrator in order to influence the identity and the skills of the chairman themselves. And just one sort of word of warning, caution, as I finish, is not to leave the selection of the chairman to the arbitral institution if you've got an institution that's the governing body for the arbitration. There is a bit of a tendency sometimes with the ICC and the LCIA and so on to, if the parties can't agree, to select somebody who is junior, who needs arbitration experience, and that is not necessarily in your interests. So always try and identify and agree, if you possibly can, the identity of the chairman in a 3-person tribunal.